Greetings and salutations, my fellow sovereigns. This is the Saturday Night Civics and Sovereignty class for the Vocational Science of Freedom, and tonight we will be covering the Magna Carta. We're going to be doing a deep dive. We're going to be reading the Magna Carta from start to finish. We may not get through all of it tonight, but that's fine. We'll just make it a multi-day event. And we'll also be going to 1215.org and looking at some of the specific articles and the explanation of what those articles mean in the Magna Carta, which Bill Thornton was nice enough to put up on his website. And if you'd like to join the Vocational Science of Freedom Gilded server, you can do so by going to the Vocational Science of Freedom YouTube page and clicking in the upper right-hand corner under the VSOF Gilded server, and that will prompt you to answer some questions, and then we'll get you in as soon as we can. And the Gilded server is where we exchange information with your fellow sovereign Americans on a free speech platform called Gilded. So with that, in chat, I posted the download for the Magna Carta, the one we're going to be reading. The Magna Carta and also the show notes will have the links to download it if you are listening to this later online. So with that, let's open up the Magna Carta and get going. And I'd also like to just say a few more things here regarding, before we get into the reading. There's a long history of law that stems back. The laws of Oleron are the first laws that were like written down as far as the, what you would call maritime admiralty. That's kind of like where they stem from. But before that, you even have certain laws that are even so much as like in story, say like the Epic of Gilgamesh. The point is, the history of law didn't start in 1776. And the more you learn about the history of law and where things changed and why they changed, the better prepared you are to understand how to grasp onto and use remedy in law that you have available to you in our constitutional republic. And so with that said, the background story, if you will, with the Magna Carta is that it was written in 1215 AD. Now, 149 years prior to that, you come to the date of 1066. And that's the date that the Normans invaded England. Now, the Normans were not very nice people, and they were basically coming over, conquered England, and then put England under the same kind of Roman civil law ideology that the English people had pretty much beaten back when Rome tried to conquer the entire island, which ended up with the building of the Hadrian Wall, which is something that the Romans built all the way across the entire island that basically said, okay, we're not coming any farther north, and we're keeping the rest of you guys out of here. And the people that they couldn't conquer were the Celts and the Druids. And there's a lot more history that I could get in with that, but I'll just leave it at that and say that the English Isles had been fought over for quite a long period of time. And the Magna Carta is a representation of that unrelenting drive and understanding that freedom is above all else. And after the 150 years from 1066 to 1215, after the quote-unquote, what was called the Norman yoke, got thrown around the English people, well, the barons of England had pretty much had enough of this. And to make an analogy of present time, we the American people are pretty much in that same situation right now. After what the international banking cartel and the attorneys did to foment the Civil War in America and what happened afterwards, meaning the Reconstruction and how they created the District of Columbia Act and created United States Incorporated and basically threw everything underneath that corporate structure and then considered all of the states to be conquered territories of that creature. We now are coming to the point where we've basically had enough as well. We're at the same point that the barons were when they said, all right, enough is enough. And they wrote down the Magna Carta and determined what was going to be in it. And they basically forced King John to sign it and said, look, you're either going to sign this or we're going to take your head off. And this happened at Runnymede. And it was a culmination of all of the oppression from the Norman yoke that they'd basically had enough of. And when we get into reading the Magna Carta, it'll be very clear the very specific points that they were absolutely determined to make sure were written down for all time and would never be altered or diminished again. And we in America are at that same point. After 150 years longer of what they've done since Reconstruction, all of the stupidity of the 14th Amendment, that they've created a secondary citizenship. They expect, are under the assumption that all of us, or by presumption, that all of us are 14th Amendment citizens, that we're citizens of the United States and not de jure people, meaning de jure state citizens, which of course are the only people that have the protections of the Bill of Rights and are the only people that are sovereign and above government. And in the Magna Carta, we're going to see where that sovereignty comes from. We're going to see what these definitions are as far as what our sovereignty is, who we are, meaning a member of the peerage, and what our power is, particularly in the form of a grand jury, which is something that's right at the end of the Magna Carta. So we might not get to that tonight as far as the grand jury is concerned, but we will at least do what we can to do a good deep dive into the totality of the Magna Carta and the history thereof. So as I said, Magna Carta was written in 1215 AD as a response of the barons against King John and the oppression of the Norman yoke and the Roman civil law forms of tyranny which the Normans brought with them, which again were just left over from Rome. And you can see that in another document that I don't have up, but it's important to understand why the barons were so pissed off. And one of those documents was called the Doomsday Book. The Doomsday Book was a Roman civil law registry type form, if you will, where the Normans forced everyone to register their lands in this book called the Doomsday Book. And it was the same kind of thing that the Romans did to require people to register property under Rome. Same thing applies today. If you register your children, if you register your car, if you register your firearms, if you register your toaster, I don't care what it is you're registering. If you register something, you're saying to the powers that which you register it with, saying, look, I'm basically saying to you, I will register it with you in exchange for the right to use the thing, but I am actually transferring title to you. And that's where a lot of people miss a big portion of what is actually going on in America regarding their rights and how the corporate government takes power over you without you even knowing it. Or not just without even knowing it, but that it was voluntary on your part. For, as Jefferson said, the just powers of government are derived by the consent of the governed. If there is no consent, there are no just powers. So, just keep that in mind when we're talking about registry. Okay, so let's get into the Magna Carta, and it starts off with basically a little beginning paragraph, and if you will, this is kind of what you would consider to be the preamble of the Magna Carta. And just so you know, this is the same Magna Carta that's off at 1215.org, and I'll pull up the site real quick. So this is 1215.org, lawnotes/magna AI.htm. and you can download the Magna Carta. And if you see links here, you can obviously, this is the same one that I'm reading from right here. Also, I'll make note of talking about the Confirmatio Cartarum, which is the confirming charter of the Magna Carta. So anyway, this is where I got the particular version of the Magna Carta that we'll be reading from. However, in this version, what I have done is I have highlighted various different words. The words in blue will be a correlation and connection to the definitions that would be at the bottom of this page that we're looking at. So immerse, seize, chattel, distrain, all these definitions here, the words will be in blue throughout the Magna Carta that we'll be reading from. So if you want to know the specific definition, come to this site and then scroll down to the bottom and look them up. And then the articles that are in red or start with red or all in red, they will be what Bill put in here as far as the understanding of what each of these articles are and what it actually means. So I'll be skipping back and forth between this link and the reading. Okay, Magna Carta, the Great Charter of English Liberty, decreed by King John at Runnymede, June 15th, AD 1215. John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy, obviously that's important, Duke of Normandy, and Aquitaine, Count of Anjou. Anjou was a province of France. To the archbishops, bishops, abbots, earls, barons, justices, foresters, sheriffs, provosts, serving men, and to all his bailiffs and faithful subjects, greeting. Know that we, by the will of God, and for the safety of our soul, and of the souls of all our predecessors and our heirs, to the honor of God, for the exaltation of the Holy Church, that's in reference to, hey, cult of Rome, we're kind of doing this in and with you, but kind of like against you at the same time, because obviously it was the barons that wrote this and not King John. But they kind of threw that in there so that the whole totality of the entire Holy Roman Empire wouldn't go at them for what they were doing. By the counsel of Venerable Father Stephen, Archbishop of Canterbury, Primate of all England, and Cardinal of the Holy Roman Church, and no, primate does not mean monkey, even though in this case it kind of sort of does, of Henry, Archbishop of Dublin, of the bishops William of London, Peter of Winchester, Jocelyn, Bath, Glastonbury, Hugo of Lincoln, Walter of Worcestershire, William of Coventry, and Benedict of Rothschild, of Master Pandolph, subdeacon of the household of the Lord Pope. See, notice that. See, all right, as I was kind of poking at, the whole aspect of the cult of Rome and what they were fighting against was still the leftover of what the Roman Empire was, okay? It was a bunch of thieving bastards that all they were ever good at was creating ledgers and mastering the administration of slaves, basically. Everything else about the Roman Empire was completely, and always will be, stolen. There was nothing great about the Roman Empire, and in fact, the people, if you want to call them that, the people that established Rome, where they came from, were Yahudi exiles. Now, the Yahudi were the human-sacrificing scumbags that came out of Tarsus, or was known as Tartarsus back then. And it was the exiles from these scumbags that ended up setting up Rome, okay? So if you really want to go all the way back and seeing what they are, these Luciferian filth, or back then it wasn't an aspect of necessarily worshiping Lucifer, they worshipped Moloch, but just another term for the same filthy entity. They were the masters and focus of human sacrifice. That's what they did. And the Greeks knew it. The Greeks called Tarsus hell on earth, literally. And so you have this progression all the way through the Roman Empire, through everything that Rome did, and then the destruction of the original republic into the empire, and everything that happened afterwards, all the way till now, meaning now as in 1215, okay? So in this document, you see the understanding of this history and why all these various different things are brought up and where all these people come from and what they were actually fighting against. Because the cult of Rome, the Holy See, was still in very, very much in control of Europe. And to this day, basically still runs Europe completely. Period. Full stop. And what the English people and the barons were saying is like, look, we recognize your power, but this is what we're doing. So there's a lot of lip service in the Magna Carta for acknowledging, but at the same time, holding Rome at bay, if you will, to say, yeah, we recognize you, but we're not going along with this anymore. This is what we're doing. So, all right. So just to say that. So subdeacon of the household of the Lord Pope, brother of Aramaic, master of the Knights of the Temple in England. Okay. Master of the Knights of the Temple in England. That's the Knights Templars, everyone. What are the Knights Templars? They are the Bar Association. They are the attorneys. The Inner Temple and Middle Temple in the City of London have been there long before the rest of England turned out to be what it was from the aspect of the Magna Carta. Now, what do I mean by that? The City of London was laid down in 43 AD by the Romans, okay? And inside the City of London, which does not belong to the English monarch, by the way, it is a separate Roman city-state. And guess who is in control of it? The Knights Templars. They are in control of it. And they are the Bar Association. Because the Bar Association, the barristers come out of 4 different inns of court. The Inner Temple, Middle Temple, Lincoln's Temple, and I think there's another one. Maybe there might be more than 4. But the point is that that's what they are. That's what the Knights Templars are. Okay? All right, to continue. And the noblemen, William Marshall, Earl, okay, so on and so forth. So a bunch of nobles he lays off, okay, blah, blah, blah. And others of our faithful subjects. So this is who we're giving this to and who we're making notice of, right? So that's like basically your preamble. 1. First of all, have granted to God and for us and for our heirs forever. Now notice that. Notice that term right there. For us and for our heirs forever. This is known in law as what's called the addendum clause. You can see it in every single original land patent. It will say in each and every original land patent, which is signed by the president, given to a sovereign, meaning one of the people, it says all of this land and so forth with this metes and bounds and yada yada shall be given to so and so, whoever it is, and their heirs and assigns forever. It means once we've done this thing is done forever. Okay? And that's called the addendum clause. And it's important to understand that this is literally the first sentence that is put into the Magna Carta. It's very important to understand that. So, first of all, have granted to God and for us and for our heirs forever, have confirmed by this, our present charter, that the English Church shall be free and shall have its rights intact and its liberties uninfringed upon. So what were they doing? The first thing they did was they established their church separate from the cult of Rome. Because everything starts with the priest class. Yes, law rules a lot of things. But guess what came before law? The priest class. Who's ever going to control your soul? So it's very important to understand that that is why that is the first sentence. They're saying, look, we're going to establish our own thing over here. It's going to be separate from the cult of Rome, and we're going to make sure that the English church has its own rights and its own liberties, and it's not going to be messed with. So that was the reason why they had to set that up first. Because again, it all starts with the priest class. It all starts with the aspect of religion and where you think you are in this universe and your connection to it, your God or many gods or whatever. That's the basis, what we have the right to believe in. Hence the reason why it is written into the first article of the Bill of Rights, that freedom of religion shall not be infringed. Same idea, same point, but in our Constitution, we say, look, we have the right of whatever religion we want, and it's completely our decision. What they were saying was, look, we're going to establish this English church, and it's going to be separate from you guys over there, and there's nothing you can do about it. Okay, so that was the first thing they had to do. And thus, we will that it be observed. Another interesting point. And thus, and I'm going to read that in a different, I'm going to read that correctly. And thus, we will that it be observed. We will. We what? We will. We will it so. This is our will. Again, an aspect of wills, of testimoniary trusts, of I give this on to thee, and this also at the time of my death shall be my last will and testament. Most people think of the term will as only being something that you write down to take care of property when you're dead. That's not what it means. Your will is whatever your will is right now. If your will is to go into your kitchen and get a drink of water, that's your will. And that's how this is written. And thus, we will that it be observed. So everything that we're going to do from this point on, it is our will that this thing be observed. As it apparent from the fact that we, spontaneously and of our own free will, before discord broke out between ourselves and our barons, and this, of course, the king talking, even though technically the barons wrote it, did grant and by our charter confirm, and did cause the Lord Pope Innocent III to confirm freedom of elections, which is considered most important and most necessary to the Church of England. Now, of course, they weren't living in a democracy. Obviously, the king was king. But what they did have was a system of free elections, and they made sure that the Church of England kept that. So, to continue. Which charter both we ourselves shall observe, and we will that it be observed with good faith by our heirs forever. So again, passing it on to the heirs forever. We have also granted to all free men of our realm, in the parts of ourselves and our heirs forever, all the subjoined liberties to have and to hold to them and their heirs from us and from our heirs. Again, this is an aspect of the addendum clause. This is literally where you get it from. So to your heirs and assigns forever, they're going to have all of the subjoined liberties. And where do those subjoined liberties come from? They come from time immemorial. Okay? This isn't... Okay, because the liberties existed before this Magna Carta was written, obviously, and your rights, your inalienable rights, exist before government. So they are not something that can be granted from same. They exist before government exists. They exist before kings exist. And could be argued that they exist even before existence exists, meaning that you had them before you even got here. So that's why they had to put this in here, because it comes from time immemorial. They're saying, look, we know these things exist. We're going to lay them down so that everybody knows to our heirs and assigns forever that they're going to be kept in good order by this document. Okay, Article 2. If any one of our earls or barons, or of others holding from us in chief through military service, that would be knight scoage, shall die, and if at the time of his death his heir be of full age. Okay, now here's the first time you see of full age, but I'll read the rest of this and come back to you there. Okay. His heir be of full age and owe a relief, which would be something that he'd actually owe back to the king, he shall have his inheritance by paying the old relief. The heir, namely, or the heirs of an earl, by paying £100 for the whole barony of an earl. The heir or heirs of a baron, paying £100 for the whole barony. The heir or heirs of a knight, paying 100 shillings at most for a whole knight's fee. And a fee is a parcel of land. Okay, that's where you get the term. That's literally where you get the term feudalism from. It comes from the aspect of fee, or fee-oath. Technically, fee-oath is where you get feudalism from, but fee-oath is an oath that you take to the king to have the land, because technically all the land is actually owned by the king. So you give him fee-oath, so then you have a fee, of which you have the right to then use that land and pass it on to your heirs in title, paying homage to the king, right? But it's something that you can pass on to your heirs. So that's a fee. Okay. And he who shall owe less than give less, according to the ancient custom of fees. So what are they doing here? This is where they're saying, this is the first aspect of, okay, if you had a fee and you can give it to your children, your heirs and assigns, this is how we're going to lay this out. So if the barons, earls, holding chief through military service shall die, time of death, the heir shall be of full age and owe a relief. So when can you take the estate? Only when you have come of full age. Why is that important? Because in the United States Code, in Title I, subsection 8, of the definition of person, all persons are infants, which I said ad nauseum, and I won't go back and look it up again, but just take my word for it, or if this is the first time you're ever listening to this, go look it up. They are treating everyone as an infant so that they cannot have what? Title. They're using it from a standpoint that you have not come of full age and so therefore cannot hold or take title. Right? And so this is the setup that they did to make sure, the first part that they set up to make sure that said, look, barons, we're sick and tired of the king completely determining who was going to take the lands one way or the other and was not honoring the rights of the heir to the fee. And as I mentioned, I mean, this was a problem that they had from the standpoint right off the get-go with the Doomsday Book. The barons were sick and tired of this. They were saying, no, we have a right as an heir to transfer that to our heirs and assigns, only if they be of full age, right? So, next one. And here's the thing. 2, 3, 4, and 5, these articles, 2, 3, 4, and 5, these are the most important articles when it comes to the understanding of passing on your hereditaments, right? The things that are passed on and come to you by what's called descent. They descend to you. They come upon you whether you like it or not because you're the heir of whatever. That's your stuff. That's your land. That's your title. That's how it works. Yes. I can restate the USC title. So I'll just type it in the chat. It's 1 USC 8 and look up the term person. Okay. And after class, I'll make sure, or I'll actually send you a private DM and I'll make sure that I give you the actual link. But you can go look it up. And what it says for definition of person is that it shall include every infant member of the species Homo sapien. Okay. So what they're trying to do is they're trying to take away your capacity as an heir. And like I said here, Article 2, 3, 4, and 5 are the most important, well, 6 too. So 2 through 6 are the most important articles in the Magna Carta, and they're right in the beginning because they all deal with heredity. They deal with what you have the right to, the right to your estate, and it shall not be infringed. So Article 3. But if the heir of any of the above persons shall be under age and in wardship, when he comes of age, he shall have his inheritance without relief and without fine. So what does that mean? It means they may not fine or fee you. Thank you, QC. It means they may not fine or fee you for what? For the right of your inheritance. They cannot do that. It's against the common law. Yet, what is this whole entire Roman civil law slavery system doing? It's fining and feeing you for the use of your own property because you have not claimed it. They say, oh, you can't smoke marijuana, or you can't put this into your body, or you can't do that with your body, or you have to do this with your body. Well, wait a second. My body is part of my estate. So how on earth can you possibly tell me what to do with my body? Oh, that's right, because my body was pledged to a corporation called the United States. Without my knowledge, of course, and without my consent, of course. But if I never raised the argument and said, hey, wait a second, hold on. I'm the heir. I'm a member of the posterity spoken of in the preamble of the constitutions. If you never come forward and claim your title as the heir, you cannot hold it because infants cannot hold title. And that's what they're doing. They're considering everyone an infant so that no one has the protections. That's the game, folks. That's what they're doing in a nutshell. So, again, number 3, but if the heir of any of the above persons shall be under age, meaning an infant, and in wardship, which is what they're doing to all of us. Everybody's in wardship. You're all considered a ward of the court or a ward of the state. And your estate, the res, R-E-S, meaning a thing, the res of your estate is being administered by special administrators because you have never ever set out what your will is. And so you're considered dead, which is another presumption. The IRS considers you what's called a decedent, which doesn't actually mean dead, but it means pending death. So they don't know if you're alive or dead. So this is the game they're playing. We don't know where you went. We don't know if you're alive or dead. And this is the bullshit that they did in 1666 with the Cestui Que Act, where they said, you're all dead to the law, and unless you come forward to claim your title and prove that you've been found to be living in an action, the crown is going to administer your estate, or the res, the stuff of your estate. So this is all done by presumption, and these are the things that we fix. These are the presumptions that we rebut. These are the things that you alter. These are the declarations that you make when you do the Vocational Science of Freedom status doc set. You correct all these things on the public record so that they can never come along and say, well, that's what you are. Even though they very rarely ever actually say it in open court, but they don't have to. It's all written in law. It's all written. Everything has been written as to what they are doing to you. The trick is to know how to read it and follow the history of what they have done. Okay? So, when the heir be under in wardship, okay, when he comes of age, he shall have his inheritance without relief and without fine. Meaning, once you prove that you have come of full age, you have all of your rights and titles restored to you. But if you do not ever do that, you will continue to be in wardship. You will continue to be an abandoned infant whose estate has been probated, who is going to be administered for your entire life. That's how the law works. Now, granted, I understand it's all by presumption, but nonetheless, this is what they're doing. Okay? That's why you have to rebut it. Okay, Article 4. The administrator of the land of such heir. Now what is that? The administrator. This is the black-robed priest of El sitting up on the bench. Bench is also Latin for bank. So the administrator rules for the bank. The administrator of the land of such heir. And here's another important point. I just want to make a point here between the definition of administrator and the definition of executor. An administrator is someone who administers an estate that does not have a will. So an administrator is someone appointed by a court to administer an estate that does not have a will. An executor, on the other hand, is someone who administers an estate who is appointed by a will to do so. So remember why it was so important up here, what I said about, and about the will part, about that we shall of our will, right, be of our own free will, and thus we will that it be observed. And thus we will that it be observed. What are they doing? They're saying this is our will. So an administrator is someone who administers an estate that is called intestate. So when an estate is intestate, it means it does not have a will. That's what the entire inferior private for-profit court system is doing. They're administering the estates of infants who have not claimed title. And it's all by presumption. And if you have any doubt about that as far as the administrator part, all you have to do is go look up the Uniform Probate Code. And it says directly in the Uniform Probate Code that the judges are acting as special administrators. Well, surprise, surprise. And we also have documentation that clearly shows, at least from one judge's handbook in Georgia, that they are running everything through probate, including, but not limited to, traffic court. And it says it directly in the judge's guidebook. So we know exactly what they're doing. This is what they're doing, and there's no question about it. So what do they mean here? Okay, so back to Article 4. The administrator of the land of such heir who shall be underage shall take none but reasonable issues from the land of the heir. Now, what's a reasonable issue? What's an issue? It's the part of the monies that the administrator gets to take from the land of the heir to basically keep it in good order. Until what? Until the heir comes forward to claim his title or her title. Right? So that's what they have to do. So they have the right to take reasonable issues to keep the thing in good order until the heir comes forward and claims it. And reasonable customs and services, and this without destruction and waste of men or goods. Now, destruction of waste or men or goods, that's a very important point. They cannot destroy or waste the estate until the heir comes forward to claim it. Once the heir has it and claims it and has full title of it, the heir can do whatever they want to with it. That's entirely up to them because it's their right. So if you have full title, you have a allodial title to land, and you want to, put an oil well on it, go ahead. If you have a allodial title to land and you build your own house on it, and then you decide to burn that house down on Tuesday because you don't like the way it looks, you can do that. No problem. But none of the property that they are administering can be destroyed or wasted whilst it's in their administration. Okay? That's also kind of part and parcel of the reason why they can tell you what to put into and what you can't put into your own body. Because you wouldn't, necessarily want someone messing up or destroying something of yours before you inherited it, right? So they're saying to the infants, no, you can't put that in your body. Or no, you can't drive that fast down the road. And so on and so forth, which is all the aspects of Roman civil law. Roman civil law is thou shalt not do because I say so. Common law is you can do whatever you want to as long as you don't cause damage, harm, loss, or injury to someone else. And obviously uphold all lawful contracts as well. So to continue. And if we shall have committed the custody of any such land to the sheriff, or to any other men who sought to be responsible to us for the issues of it, and he caused destruction or waste to what is in his charge, meaning what we gave to him, to look over, to administer, we will fine him. And the land shall be handed over to 2 lawful and discreet men of that fee, who shall answer to us, or to him to whom we shall have referred them, regarding those issues. So, what are the 2 lawful and discreet men in modern days they keep handing over the estate to, right? Or the land and the estate. What are the two men? The judge and the district attorney. The judge and the district attorney. The judge and the exactly, Janice. You actually typed it in before I could even say it. That's what they're doing. They're just passing it on to 2 lawful and they think they're lawful and discreet men of that fee. That's what they're doing. We're actually following the Magna Carta. Is that any surprise to anyone? Not to me. Because everything that they're doing is lawful. And I know people hate to hear that. But it is. They do not go against law. What they do is they use various different jurisdictions of law, which you should never be a part of, against you. Because you don't know how to get out of them. So anyway, so that's what they're doing. So 2 discreet lawful men, pass it on. And another thing about this too, this is the reason why, if you have a lawsuit, and I'll just take for sake of argument, I'll take a mortgage foreclosure, okay? So say there's a bank and a mortgage foreclosure comes against someone, they foreclose on a house, right? Okay, the attorney, there's something called an attorney of record, and the attorney of record has to file into the case that they are the attorney of record. Why? Well, they're saying for the public record that they happen to be one of the 2 lawful and discreet men of that fee. Now, interesting thing about that. If you ever come across any court case, I don't care what it is, but we'll just continue with the mortgage foreclosure as a sake of argument. So you come across and you start looking up something in a mortgage foreclosure, say it's your own or say it's somebody else's, doesn't matter. And you find that such and such attorney, John Doe, filed ABC into such and such case on Tuesday. Well, you go back and you look up to find out that John Doe isn't the attorney of record, that it's Jane Smith. Well, guess what? Everything that John Doe filed into that court case can instantaneously be removed from that court case simply by you going to the clerk and demanding that it be removed. And yes, we've done this before in foreclosure cases for people. The attorney of record has to be on record. And if someone's filing something in there that's not the attorney of record, you can have the clerk remove it. I don't care if it's a motion for summary judgment. I don't care if it's a motion to quash evidence. I don't care what it is. Doesn't matter. Doesn't matter. You can go in there and tell them to remove it because they have to be on record as the attorney of record. And where does this stem from? It stems all the way back to 1215 AD from the Magna Carta, right there in your face. Okay? All right, to continue. And if we shall have given or sold to any one the custody of any such land, and he shall have caused destruction or waste to it, he shall lose that custody, and it shall be given to two lawful and discreet men of that fee, who likewise shall answer to us, as has been explained. So again, they're passing it on, passing it on, passing it on. So how are they doing this? From the standpoint of, if they have a whole entire nation of infants, which is what they're doing, then they can just keep moving and deciding who's going to be the administrator of the land, or of the thing, the res, whatever it is, even the body. They're going to pass it on to the pass it on, then pass it on and pass it on. Why? Why can they keep passing it on? Because no one is coming forward and claiming the title and proving that they've come of full age, which is what we do with the VSOF doc set in a proof of life and proof of age inquest, which, by the way, is the only way to do it under the common law, is by inquest, and say, no, stop. I'm the heir. This is mine, not yours. You have no right to administer. And, oh, by the way, I'm the sole lawfully appointed executor of said estate. That's how you stop them. Or the only way we're going to stop them dead in their tracks, save 25-member grand juries, which we will get to later. Okay, so that's number 4. Number 5, again, this still deals with title from an aspect of being an heir and things devolving to you. Okay, so the administrator, moreover, so long as he may have custody of the land, shall keep in order from the issues of that land the houses, parks, warrens, lakes, mills, and other things pertaining to it. And he shall restore to the heir, when he comes to full age, his whole land stocked with plows and wainages deals with the waxing and waning of the moon. So basically what they're referring to here are the things needed to take care of and perpetuate crops during whatever season it may be. So that's speaking of the wainages. Okay, so his whole land stocked with plows and wainages, according as the time of the wainage, meaning the time of the moon, requires, and the issues of the land will reasonably permit. So what is it saying? What does number 5 say? It says, the second that the heir comes to full age, he gets everything back. All of it. And that's what no one's doing. And that's what they're holding over you, is the greatest presumption. But that's what we correct with the VSOF status docs, to make sure that the heir is restored to all of it. Because only when you come of full age can you have title. Because again, an infant cannot hold title. Okay? Number 6. Heirs may marry without disparagement, so, nevertheless, that before the marriage is contracted, it shall be announced to the relations by blood of the heir himself. This just basically means you have the right to marry whoever the hell you want to, and without disparagement. So, meaning that you can't be forced into an arranged marriage, is more along the lines of what number 6 is getting at. Number 7, a widow, after the death of her husband, shall straightway, without difficulty, have her marriage portion and her inheritance, or shall she give anything in return for her dowry, her marriage portion, or the inheritance which belongs to her, and which she and her husband held on the day of the death of that husband. And she shall remain in the house of her husband after his death for 40 days, within which her dowry shall be paid over to her. Now, the aspect of dowry is the amount that a widow gets. These things aren't really followed anymore as to the severity and the specificity of common law that they used to be. But what it was a protection for widows. Say, the husband was the sole bringer in of money. Obviously, in those cases, that was pretty much always the case. And so that the widow had the right to be taken care of by the estate of the dead husband. And so all these things were laid down in law to make sure that you didn't have old women basically having to wander around on the streets as beggars and paupers. So all these things were taken care of to make sure that the wife of the husband was always taken care of. Okay. Number 7, again, dealing with widows. No widow shall be forced to marry when she prefers to live without a husband. So if there was say the husband had a very large estate, and she then inherited what she did. No one could force her to marry another man so that that man could then take control of that estate. She didn't have to do that. Said nope. She could live out the rest of her life on her estate, free and clear. No one can mess with her, right? Can't be forced into marrying again. So, however, that she gives security not to marry without her consent if she holds from us or the consent of the Lord from who she holds if she hold from another. Now that's an aspect of, again, the aspect of who holds the fee, right? So the fee would be part of the estate of the man, of the male, the husband, and so make sure that all the things were taken care of correctly. And in saying this part, that she holds from us, meaning the grant from the king or from the earl or baron. But of course, remember, this is the king talking here, so that it's not taken away, right? So that fee, the fee hold, stays with her. So number 9, neither we nor our bailiff shall seize any revenue for any debt, so long as the chattels of the debtor suffice to pay the debt. Nor shall the sponsors of that debtor be distrained so long as the chief debtor has enough to pay the debt. Now I'm just going to pause here in the middle of this and click onto the chattels and distrains. Okay, so what do these things mean? Okay, so this is where we bring up the 1215.org site, and I'm going to put this next to the definitions here and scroll down to the bottom so we can take a look at these. Okay, so what on earth is a chattel? So chattel, personal property as opposed to real property, a personal object which can be transported. Okay, so personal property is your stuff, like your cups, your backpack, your toothbrush, your bike, right? Real property, this is an aspect of land. So when you call real property or real estate, that's land. That's stuff that cannot be moved. So the land cannot be moved, but personal property is the stuff that can move around. So that's a chattel, a personal object which can be transported. So, neither we nor our bailiff shall seize any revenue for any debt, so long as the chattels of the debtor suffice to pay the debt. And, well, I was going to get to an aspect of the money lenders, but they actually get into that later, so I'll leave it for a later time. Okay, nor shall the sponsors of that debtor be distrained. So what does distrain mean? Distrain, the act of taking as a pledge another's property to be used as an assurance of performance of an obligation. Also a remedy to ensure a court appearance or payment of fees. So what's a more modern term as far as that's concerned of what you would consider to be a distrain? Well, usually it's called collateral from a standpoint of a loan, right? So you put up something as collateral and you get a loan from a bank. Okay, same idea. So a distrain, the acting as taking a pledge of another's property to be used as an assurance of performance of an obligation. Also remedy ensure a court appearance or payment of fines and fees, etc. All right. So when you look at this, go back and read it. So, nor shall the sponsors of that debtor be distrained so long as the chief debtor has enough to pay the debt. So if you were to come along and you were to pledge, say John owed some, Jew 100 pounds or something, and you came along and you said, hey, I'll be a sponsor, right? I'll make sure that, if you don't get it from John, I'll make sure that it gets paid, right? You put that into the contract and the money lender says, okay, good, fine. I'm cool with that. Now I'll lend John the money because maybe John doesn't have all that much and maybe John's a little risky, right? This is where in modern days you get things like credit reporting agencies. It's that mechanism of trying to figure out whether you're going to be a good boy and pay back the money lenders, right? So this is what you had back then before you had something called a credit score. So anyway, so the debtors be distrained so long as the chief debtor has enough to pay the debt. But if the chief debtor fail in paying the debt, not having the wherewithal to pay it, the sponsors shall answer for the debt, which is obvious because this was a contractual aspect of how they said, yep, all right, you're going to be the secondary guy that comes along that we're going to come after for the debt if you can't pay it. And if they shall wish, they may have the lands and revenues of the debtor until satisfaction, right? So if they shall wish, they may have the lands and revenues of the debtor until satisfaction shall have been given them for the debt previously paid for him, unless the chief debtor shall show that he is quit in that respect towards those same sponsors, meaning quit, as in not going to deal with you, or shows that they've basically quit, or that they've quit him, meaning I'm not going to sponsor you. I'm not going to have your back anymore is what that means. So this is an aspect of, and it's very important. Number 9 is very important because they were dealing back then a lot with moneylenders, with Jews, and the Jews ran their own laws, the aspect of the law merchant, and they had kind of their own rules that they've had for a long time. And that, of course, again, is the law merchant, which I won't get into right now because we're almost at the end of the hour. But the point is that the law merchant runs and operates entirely differently than the common law does. So what did the barons have to do? The barons said, look, we're going to lay this thing down so we have certain protections, certain things laid out in the common law regarding debt and regarding sponsors and regarding the repayment of debts and debtors and who can take what from who, when, where, and whatever. And to make it a comparison, you see the same thing in the 12 Tables of Rome when you're talking about what the plaintiff could do to a debtor who did not pay, right? In the market court, when you went and dragged someone to market court, you say, this guy is a debtor, he owes me, this is the contract he signed, he hasn't paid, blah, 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 so on and so forth. Well, in Rome, it was just a little bit more severe. In Rome, if a debtor didn't pay and you got a judgment against them, literally it was up to the plaintiff to then extract the monies owed from the defunct debtor, or the defendant in judgment, if you will, even though they didn't call them defendants and plaintiffs back then. But anyway, if you had a judgment against them, you could do whatever you wanted to that guy, including, but not limited to, put him into chains and sell him as a slave over the Tiber. Tiber meaning the Tiber River. Right? It's pretty serious back then in Rome. And that's how the law merchant ran pretty much everything, because you got to remember, again, who founded Rome and their filth about debts and debtors and what you could do to them. Well, luckily, mankind has taken a look at all that and pretty much said, yeah, we're not doing that. Which is the reason why we specifically have protections in our constitutions that there shall be no debtors' prisons, right? You can't do that. What you have the right in the common law to do is take everything that he did have title to, but you cannot throw the debtor into prison simply because he didn't pay the debt. So, okay, so with that, we stopped here at 9. I'm just going to make a note here in green so we know to come back here. Just so you know, I put the link for the 1215.org link into chat on Gilded as well. And also make sure to, if you're listening to this online later, the download for the Magna Carta will be in the show notes. And I will also probably do my best. I'll also grab the Confirmare Cartarum, which is the confirming charter, which is the document that was written in 1297 AD, which was 82 years after the Magna Carta, which by basically the next king after John basically confirmed the Magna Carta in this document, the Confirmare Cartarum, and it said that the Magna Carta must be accepted as a common law by government. The Magna Carta is the supreme law. All other contrary law and judgments are void, and voluntary taxes cannot be permanent. So I will maybe read the Confirmare Cartarum after we get done through the Magna Carta, but for now I will leave it at that. We'll start back up with Article 10 when we come back to the next Saturday Civics and Sovereignty class. So with that, I'd like to thank everyone for coming, and I'd like to thank you very much for everyone for participating and joining in tonight. If you found this class to be informative, please like and subscribe to the Vocational Science of Freedom, because the more you learn, the more powerful you'll become. So have a good weekend, everyone, and until next time, stay safe and stay sovereign.